Hello, I'm Stephen Morse from the Penn Law School. The topic of my presentation and of my chapter for the Academy for Justice is challenges from within the criminal law and from without to the importance of mens rea specifically and culpability more generally. I argue that these are very unfortunate challenges and that they should all be rejected. I begin by talking about the importance of mental states, flowing from the law's implicit psychology that places a great deal of emphasis on mental states. Then I turn to the two challenges themselves. The internal challenge is in the context of the relevance of mental disorder to mens rea and culpability. The external challenges are more radical challenges to culpability more generally, flowing from alleged advances in the new behavioral neuroscience and new behavioral genetics. Following that, a brief conclusion. Let's start with the importance of mental states. The law's implicit psychology is folk psychology. That is a causal psychological theory that says that mental states matter to our actions. And in fact, if you think about law, law is an action guiding mechanism. It gives us reason to do one thing versus another. We don't give machines reasons, we give people reasons. People who can potentially act for reasons, which is what folk psychology says of human beings. This is known as the causal theory of action. Our mental states matter. Now, they are the crux of agency and responsibility. We would not think for a moment that machines, even the most complicated biophysical machines, are agents and responsible, unless they could absolutely duplicate us. And we believed in the causal theory of action, which the law does, and most of us do. Lastly, why are the differentiations among the mental states important? Because they give us the best indication of the attitude of the perpetrator towards the rights and interests of other people. In general, and obviously there will be counterexamples, people who kill on purpose are more morally culpable than people who kill recklessly, that is, with conscious awareness of a risk that they are behaving dangerously. And all the subjective mens reas are more culpable than negligence, which many people believe should not be considered a mens rea at all. In cases of negligence, that is, people are not consciously aware of the risks they are running to the rights and interests of other people. Okay, let's first turn to the internal challenges in the context of mental disorders relation to mens rea and culpability. I acknowledge freely that there have been many strengthening and robust reforms to make mens rea requirements more certain in the criminal law. But the mental disorder context is a counterexample in Supreme Court jurisprudence, which doesn't say that states can't take mental abnormality into account, but it does give them permission not to if they don't want to. And that is, I think, the mistake. Let's start with voluntary intoxication, in which the Supreme Court said in the middle 90s, in a case called Egelhoff from Montana, that a state could constitutionally exclude clearly relevant, clearly probative evidence of mens rea if the person trying to introduce it had been voluntarily drunk. Let's concede for a moment that, in fact, drinking and becoming drunk is a great evil. If it's a sufficiently great evil that it, in most cases, causes human beings to act contrary to the rights and interests of other people, then it should be criminalized in itself. But we don't believe that. And what we know is that although alcohol may disinhibit people, alcohol and drugs, other drugs, I should say, may disinhibit people, it doesn't cause, in most cases, them to behave in very serious criminal ways. So the relation between alcohol and otherwise criminal behavior is not very strong, with the exception, obviously, of drunk driving. And probably most cases of drunk driving don't, as bad as it is, and let's make no mistake about that, do not end up with serious injury, given the enormous number of incidents per day of drunk driving in the United States. So suppose we were to allow somebody to negate purpose, knowledge, recklessness, and even get down to negligence. What would be the danger in that? the person would still go to prison. They would still be culpable as long as they had a mental state. And note, you can never negate negligence because negligence is essentially an objective state. What would a reasonable person have been aware of? And if you're drunk, you're by definition not a reasonable person. So let's take Egelhoff himself, who killed 2 people while allegedly really wasted. He probably had a blood alcohol content of 0.4. That's right, 0.4, not 0.04. At the time he shot at point blank range and killed his victims. Unless he had a history of knowing he did things like that when he got drunk, and virtually nobody has a history of such persistent antisocial behavior at that level, that by just simply getting drunk, they know they're putting themselves in that position. He might have gone to prison, let's say, for involuntary manslaughter. That would have been a very long prison term. He's not likely to do it again. So there's no particular danger. And the people who don't have such a history really don't have a mens rea, and therefore they were not indifferent to the rights and interests of other people. Now let's talk about mental disorder. As is well known in Clark against Arizona, the United States Supreme Court said a state could channel all mental disorder evidence into the insanity defense and did not have to require a state to admit otherwise completely relevant and probative evidence of mens rea negation based on mental disorder at the prima facie case. Once again, I think this is really unwise. Negation of mens rea is not a mini affirmative defense. It's a full stop, full-throated statement that the defendant did not do the crime charged. Because as lawyers know, doing, quote unquote, the crime charged means that in fact, you had the mental state required by the definition of the crime. You had the mens rea. And if you don't have it, you don't have it. So why and you don't show the kinds of indifference to the rights and interests of your victims that having a particular mental state would otherwise indicate. So why are there so many limitations on the introduction of mens rea evidence, of mental disorder evidence on mens rea, even in those jurisdictions that do permit it to some degree? And many jurisdictions like Arizona do not permit it at all. The answer, I think, is a fear that we are going to be knocking down the degree of blame and punishment, reducing it, and therefore we're going to be releasing dangerous people early. If that were the case, that would be a real danger. But that completely misunderstands the relation between mental disorder and mens rea formation. Mental disorder, even severe mental disorder, almost never prevents a defendant from forming a mental state. What it typically does is it gives the defendant a reason to form it. Think of Daniel McNaughton. He thought the Tories were out to kill him. He thought the only way he could save his life was to assassinate Prime Minister Peel, and he tried to assassinate Peel, but unfortunately for Peel's secretary, Drummond was in Peel's coach that day and took the bullet. So Peel lived, but transferred intent, and Daniel McNaughton was tried for intentional murder, and of course he killed intentionally. But he was motivated by craziness. In his case, the craziness of the delusional belief that the Tories were out to get him, which simply was not true. So if we really understand the relation between mental disorder and formation of mens rea, there will be very little danger in even allowing any case the full use of mental disorder to negate mens rea. And that would bring culpability much more carefully into line with the outcome of the prima facie case. Now let's turn to the insanity defense. As is well known, earlier this year, 2020, the Supreme Court decided that no independent affirmative defense of legal insanity was constitutionally required. Kansas had an alternative to the affirmative defense of legal insanity, which said that you could use mental disorder to negate mens rea. So the Supreme Court said this is the equivalent of an insanity defense. So we are taking mental disorder into account in considering culpability. We're not entirely excluding it. And remember, even Arizona had an insanity defense, even though it didn't allow evidence of mental disorder to negate mens rea. Well, If the mens rea negation alternative produced full acquittal in those cases in which full acquittal seems correct, then that would be, I would argue, a reasonable alternative to the insanity defense, because mental disorder would be fully taken into account. The problem was that the majority failed to recognize the point I just made about mental disorder and mens rea negation. Almost never will mental disorder negate mens rea. So all the people who you might think really were motivated by such delusional reasons or hallucinatory reasons and the like really do not deserve blame and punishment. They will be blamed and punished fully because they would form mens rea. Now, the facts in Colorado are not very favorable to the insanity defense, but a prior case in which the Supreme Court denied cert on the same question, is an insanity defense constitutionally required, Delling from Idaho from 2013 is even more instructive. Delling delusionally believed his victims were sucking his brain out of his skull, genuinely sucking it out somehow, and he was going to be killed by them. So he carefully planned their assassination because he believed he needed to do so to save his own life. This took place in Idaho, which had the mens rea alternative. Delling was clearly guilty of intentional murder. His delusional system gave you the reason he formed the intention. And the trial judge in that case said, but you know what, this guy didn't know right from wrong. But that was tough on Delling because Idaho had no insanity defense. So even though the history is uncertain about whether an insanity defense is part of our traditions of just punishment and the like, if there was an alternative, I would be satisfied. But there is no alternative because of the actual way that mental disorder affects mens rea. Now, once again, there have been many encouraging signs that I acknowledge in mens rea reform. But in the context of mental disorder, these three lines of permission the Supreme Court has granted jurisdictions are very disquieting because they are really driving a wedge between culpability and social safety, with really the emphasis on culpability. And I think that is very unwise in our system. Now let me turn to briefly, because the external challenges, the challenges that is from advances in behavioral neuroscience and behavioral genetics, have led many external critics to say we're not responsible agents. This comes in two flavors. I'll just give you the flavors and then give you reasons to reject. But since it's gained so little practical foothold, despite many, many thoughtful people making this argument, I thought we ought to mention it because it goes certainly hand in glove with what I've just been talking about with mental disorder. There are two interpretations of the radical challenge. The first is what you might call epiphenomenalism. That is, we are just very complicated biophysical machines that do throw off mental states. We do have mental states, but they don't do any causal work, not even partial causal work in explaining our behavior. If that is true, law is a useless enterprise and culpability is gone, generally, because if our mental states do not matter, we are not agents and we have no reason to do anything. And the way to think about this claim is that the physical universe throws off things that occur, like mental states or the foam on a wave, but those things that occur play no causal role in the universe. So the way to think about our mental states would be like the neuronal foam on the wave. It doesn't at all power the wave. It just is produced by the physical forces of the universe. This may turn out to be true. I strongly doubt it, but I don't have time in this brief presentation to tell you why. Let me just say at present, and I want to stress at present, because who knows what will come out of a laboratory or a conceptual think tank tomorrow. At present, there is no conceptual or empirical reason to believe our mental states are epiphenomenal. They seem to play a causal role. The second radical challenge is called hard indeterminism. It's largely being pushed by philosophers, not by lawyers, although there are a few lawyers who are on board. The claim here is our mental states are part of the causal chain, but because we are just the end product of a completely deterministic causal chain that produces things that matter, but there was no alternative. What you decided to do, deciding to listen to this presentation, you had absolutely no real choice in the matter. Your belief that you would learn something, your intention to listen, were in fact important as part of the causal determinants, but those were the only decisions you could have made. There was no alternative. This has a very good philosophical pedigree, this particular way of thinking. There is a convenient answer in philosophy of mind, action, responsibility, which says even in a highly deterministic universe, we can still be moral agents. It goes by the title compatibilism, and it comes in many forms, but they all accept that even if determinism or something quite like it, physicalism plus causal closure, is true, we can nonetheless be moral agents. There's no way to resolve this metaphysical debate at present, and there never will be, because we can't get outside the universe and look in. So at this point, my response always is, let's look at what the world looks like if we live in the hard incompatibilist universe, and let's look at what the world looks like in the compatibilist universe, which is something we've implicitly had now for 1,000 years in Anglo-American law. Do I want to give up autonomy, liberty, personhood, all the things that make life richly worth living, on a theoretical argument that cannot be in any ways conclusively proven, that would lead to an entirely illiberal prediction and prevention scheme of social control? And my answer is, I don't want to live in that world. Most of the people arguing for it do not give specifics. Those who do give specifics, what the actual world is going to look like, it isn't pretty. Big brother and big sister will be watching you. So on that note, I end my presentation and thank you for your attention.